This matter is before the court on the defendant's motion to compel answers to interrogatories, request for production of documents, as well as the objection to the 7-day order. Court does note that Ms. Reed had filed an answer. I've reviewed the answer as well. Ms. Gillum, is there anything else you'd like to add?
Your Honor, I would just like to note that this discovery has been outstanding since December 6th. We did receive obviously some updated information after we filed this motion. However, discovery deadline has since passed. It's passed quite some time ago. And we're asking the court today to extend that deadline as well, just because some of the stuff that he's provided us has led us some more questions, and we'd like to get some more information as a result.
Okay. Well, I know in reviewing Ms. Reed's answer, she states some of the documents you've requested don't exist. They don't, such as the work schedule. So there is no work schedule. So how can he provide it?
And we said the same thing, Your Honor, when they asked us for our client's work schedule, and we were ordered by the court to produce a work schedule anyways. And my client did. She actually recreated a work schedule from her memory.
Okay.
I mean, and I understand as far as really, Judge, he provided us when we asked for evidence regarding his monthly bills. He provided, instead of providing us a copy of his bills or any receipts for payment, he provided us with screenshots of what appeared to be from a bank account. We don't know whose account it is. It doesn't have any identifying information. And there's only 4 days from that month, from the month that we're asking for an evidence of your monthly spending, Judge. So he hasn't provided us with the requested information. We're asking for documents regarding childcare. He says he pays his childcare provider in cash, and that might very well be true. But if that's the case, then he can get an affidavit from his childcare provider or provide receipts of the payments that he's made, which he's done neither. And then regarding his income, and then the medical records, he didn't provide any medical records for the child for the time that he had the child here in Michigan, and the doctors that he took her to in Michigan.
He states that your client has all the medical records.
Now he states that she can get them. So he's put the onus on her to get a request and request those records.
Okay.
And then we've asked numerous times for these documents. I've sent her a number of emails requesting this information. We've also requested photographs of the child's room in his home, which, as the court knows, is definitely relevant to parenting time in custody. And he's not provided those as well. Instead, he's saying that my client should have those photographs. I mean,
well, if she lived in the home, wouldn't she know what the bedroom looks like?
Your Honor, she never lived in their home.
Okay.
She may have visited there over a year ago. But that being said, I mean, I'm sure a lot has changed in a year and a half now that their child is staying with dad. So if she has a bedroom and a bed, then that should be provided.
Okay. Ms. Reed, why can't he provide a picture?
It's my understanding that Miss Arizola Velez did live in the home, knows exactly what this child's room looks like, and upon information, I believe has pictures of the child's room.
Well, what the court will do is simply order that the plaintiff would comply and file an answer as best that he has within 21 days of today's date. And he can provide a picture and have him take a picture and provide it. Likewise, I did require that the defendant would reconstruct her work schedule. He can do the same thing. I'm not going to order that he provide his social security number. As in the answer, it already stated some of the other documents had it on it. So again, she would have that. So there's no reason to duplicate that. And that he can provide, and if he's providing a bank account to show what his expenses are on a monthly basis, he can at least identify what those are based upon the document that he provides. So court will require that all that be done within 21 days. And court will reserve on any attorney fees at this point.
Your Honor, we did provide amended responses to the interrogatories where we outlined all of that information, as well as providing updated information. My issue is we're under the under the court's order, we would be providing the same information again.
If you've provided, you can simply say it's already provided and give her the date that was provided. For instance, she's stated on regard to the child care provider that you can get an affidavit from the child care provider. We'll do it then. That's very easy to do. So get that and provide it. I'm at this point, I'm loath to extend the deadlines for discovery because I don't know what would be necessary. We'll provide that within the 21 days. If you believe there's something deficient or you need something additional, you can file a motion to extend the discovery deadline at that particular point. But I will tell you, unless it's something that's compelling, the court's not going to extend the deadline.
Okay. And then regarding the work schedule, my client has provided time cards, which specifically outlines exactly when he has worked. So now, just so I'm unclear, he's going to have to go through his time cards and just write down when he works to provide her the same information again?
Well, if Miss Gillum can't, I guess you say, if she can't understand the time cards, maybe that's what he's going to have to do so that she can be assured that that's the time he's working. So have him do it, prepare it, get it done, and then hopefully we can get this matter moving forward.
And Your Honor, what about the medical records?
He can provide any medical records that he has or that he can acquire as it relates to medical provided while the child was, been in Michigan. Okay. Thank you, Ms. Gillum. You can prepare the order, submit under 7-day notice of entry. Court will end this matter at 10:08 a.m. You're free to go. Have a good day.
We
Your
still
Honor, there's one more motion.
Okay.
And I actually, okay, go ahead, Your Honor.
Well, go ahead.
Oh, so it's just the 7-day order and our objection to that 7-day order. There was some issue with the wording of the proposed order of plaintiff's counsel. And since then, Judge, we have provided a recreated work schedule by my client. So I think that this issue should be resolved. We're willing to enter an order if the opposing counsel is indicating that we provided her with the recreated work schedule.
Okay. Ms. Reed, did they provide you with what you had requested?
I did see it listed in the almost 300 pages or 900 pages of exhibits that I got. I have not had an opportunity to review that schedule in its entirety with my client, but if it is complete, we could enter a step to resolve the issue.
Okay, why don't you do that, and hopefully you can. If not, then bring the matter back before the court. Court will note the appearance of Ms. Beecher on behalf of the plaintiff, Ms. McKenzie on behalf of defendant. The matter is before the court on the defendant's motion to change parenting time, exchange, and counseling. Ms. McKenzie, have you seen Ms. Beecher's response in which she's basically saying they're not opposing counseling and they agree to the make-up parenting time as well?
Yes.
Okay.
Yes. What I'm looking for, though, specifically, Judge, is I'd like some counseling between Mr. Johnson is seeking some counseling between himself and Ms. Davis, as well as the counseling between Olivia and mom. The counseling between Olivia and mom, I suggest, Your Honor, take place with Olivia's counselor. We'd also like the order to include that the children are allowed some leeway to choose extracurricular activities, even though they may fall on mom's parenting time, which, just season-wise, the kids don't have control over that. The parents don't have control over that. If you're participating, sometimes it's going to be on mom's weekend. So if we could get the counseling ordered, the exchange location's already been decided upon. We do have a step somewhere in the court chain of procedures coming to the court. And we certainly are happy for some makeup time for mom if you want to count. The court wants to count extracurricular activities that occur on mom's weekend where mom is simply unable to attend. We're happy to call that time missed with mom and offer some makeup time. And then during that situation, if the court could also order that Mr. Johnson would have the right to pick up the children at Mrs. Davis's home in the event that she's not going to attend a practice, a clinic, like a tumbling clinic with the girls, or or a competition. Mr.
Okay.
Johnson would have the right to do the transport on that so the kids can get where they need to go. But we do need some assistance with the schedule so that Mrs. Davis does have, she doesn't miss too many hours with the children. They just might be on, that parenting time just might be on different days.
Okay. Ms. Beecher, you have any problem with continuing the counseling with Ms. Deggs?
Well, Your Honor, my client's not opposed to the counseling, but when she has inquired with Olivia, the minor child, Olivia did not want her to attend. She said that it was something that she was doing on her own, and she didn't want parental involvement. And so my client's not opposed if Olivia wants her to attend, but if it's something that she's doing, in a private manner to speak to this counselor, I don't know if it's the defendant or the actual child that wants them to attend.
Well, why don't we do this is just put that the counseling would proceed with Ms. Deggs, but again, it'll be kind of at the direction of the counselor. So if the counselor wants mom to appear, then fine, and she can meet with mom individually or meet with them together, et cetera. It'll leave it up to the counselor as to decide. Do you have any problem with why does your client not, I guess you say, allow the kids to participate and do the, for instance, like Olivia with cheer and those types of things? Why does she not do that?
She does. It has been a little bit of an issue, and we do have a referee hearing coming up for denial of parenting time because often she's not able to retrieve her child during these times, and she doesn't know her whereabouts. She'll go to friends and things for the weekend, but she will attempt to take her. Some of the cheer competitions are even in excess of 3 hours away. So that's why she asked that she be involved in some of the school related sports, opposed to these traveling teams where the children have to, drive 3 hours one way to get to them.
Well, a lot of kids do that. So it's not an unusual situation where kids are involved in traveling squads for all, a myriad of sports and other type things. So if it's something that Olivia wants to do, the court would order that your client would facilitate those particular practices, games, things of that nature. If she's not available to do that, apparently the defendant's offered to provide that transportation, and court, I guess, Ms. McKenzie, you can include that in the order that if Ms. Johnson is not able to again facilitate those particular events, that the defendant can provide the transportation.
I will do that. Thank you, Your Honor. What about counseling regarding the part between the parties, Judge?
Well, I guess I'll leave that up. If the parties want to do that, the court has no problem. If either one of them saying I'm not going to attend, then so be it. And they'll just have to put up with any difficulties that they have because they haven't participated in some sort of co-parenting, but I'm not going to order it this time.
All right.
Thank you.
Thank you, Your Honor.
Thank you. That will conclude the matter. Ms. McKenzie, you can prepare the order on a 7-day.
There we go. Calling case
Matter
2004.
before the court on the defendant's motion to show cause. Ms. McKenzie.
Thank you, Your Honor. We're asking the court to hold Ms. Mitchell in contempt for a scene that she caused in Dr. David, my client, pursuant to the court's order of November 14th, 2022, made an appointment with Dr. Byron's to have the party's child, 9-year-old date seen. And also pursuant to the order, my client went ahead and notified Ms. Mitchell of the appointment. And she first tried to cancel it with Dr. Byron's office, and then in fact did appear, and this was on the January 26th of this year, and caused a complete scene. The PA who was seeing little David was just flat out refused to continue to meet with him and provide any treatment at all. In fact, the PA ended up calling security because Ms. Mitchell caused such a scene and screaming and yelling and so forth in front of the staff the doctor, the PA, the rest of the patients. It was quite a scene. And during this time, the plaintiff mother also spoke with little David after the PA said, I can't help you today. I'm not going to treat your son. The plaintiff mother took the child aside in the exam room and was feeding him her same old line about, we're going to be safe soon. Daddy can't hurt you anymore. Daddy can't hurt us anymore. This has been a lie from the get-go. And it has been a lie for years, but she's shouting this at the child in the doctor's office. But in any case, Dr. Byron's fired my client as his patient. And my client has been Dr. Byron's patient since he was a little kid. And Dr. Byron's, of course, in the same letter firing my client, refused to treat David. So these actions were contrary to the inalienable rights paragraph of the court's previous orders. They're contrary to the best interest of the child. The best interest of the child, Your Honor, we are at a point where Mr. Stone, for the safety, physical and emotional safety of the child, needs to have temporary custody of the child pending this court's evidentiary hearing, which is coming up on March 28th. And that's in regard to several other matters and also another show cause. We have 9 show causes, including today's, Your Honor, the court has issued 9 orders against Ms. Mitchell. She has failed to comply with any order at all, except quite recently, she has, since hiring attorney Graffos, she has appeared at 2, possibly 3 conferences, co-parenting conferences with Ms. Katz. However, last week, Tuesday, she walked out of that. She became explosive and mad about it, mad about the discussion topics that Ms. Katz was taking up with the parties relating to co-parenting. And she went screaming and storming out of Ms. Katz's office. I did file the child on Monday, 1 week ago, Your Honor, had a complete emotional breakdown at Daddy's house. Last week was Daddy's week, and had a complete emotional breakdown at Daddy's house, and I did file affidavits in support of this from Grandpa. Supplied those to Mr. Graffos also. The second affidavit was from Counselor Katz, who outlined Ms. Mitchell's actions during their co-parenting session on February 21st. But on February 20th, Monday the 20th, the child became completely out of control at Dad's house. And finally, Grandpa Stone was able to get little David calmed down. Grandma was called to the house. Mother was called to the house. Grandpa was called to the house. So only Grandpa was able to get the child calmed down and find out what in the world was the problem. And the problem was that the child had been told by Mom and others at Mom's residence. Mother lives with her parents. But Mom and others at her home have fed the child information that he is unwanted by his father, that he is hated by his father, that he is unwanted by the Stone family, by Grandma and Grandpa Stone, who have known him since birth and have had him extensive periods of time. So not only is Ms. Mitchell bad-mouthing the father of her child, but she's also attacking the child's extended family, his grandparents, his aunties, besides just being offensive, it has become a problem. And that is what we believe that has led to the complete emotional breakdown, where the kid trashed his room. He had a knife and carved up his bedding, his lamp, his television set, the whole 9 yards. It was quite a scene. And it was only Grandpa Stone that was able to get him calmed down. And my client, for the court's information, and I think I've mentioned this to Mr. Graffos, we do have little David in counseling. There is another co-parenting counseling session, I believe, for tomorrow between the parties with Ms. Katz. But this child's physical and emotional safety require, Your Honor, all due respect to the court, it's time to move this child temporarily. I understand the court will need to have a complete hearing, but the change of circumstance and proper cause that exists are the emotional safety of the child requires a temporary change of custody. I suggest both physical and legal. And I suggest the legal change of temporary legal change of custody solely to Mr. Stone for the reason of Ms. Mitchell's actions in Dr. Byron's office. The best interests of the child are not foremost on her mind. And this child is physically and emotionally suffering. It was a very dangerous situation on Monday. And thanks to Grandpa Stone, the child did calm down. But my client did take little David to Serious City Peds and was able to be seen there. There is a game plan for some an ADHD evaluation and a psychiatric evaluation. But, you know, thanks to Grandpa Stone, this child did get to the point where he calmed down enough to, you know, rejoin the rest of the family and come out of his room, his locked room, and so forth. But it was a dangerous situation. I'm asking the court to prevent that by granting Mr. Stone temporary fiscal and legal custody until such time as the court rules on the motion that is currently set for March 28th for a half-a-day evidentiary hearing. Thank you, Your Honor.
Okay.
We're also asking for attorney fees, of course.
Okay. Mr. Graffos, what's your response?
Your Honor, first regarding the reason that we're here today on this motion on the show cause regarding the incident at the doctor's office, I believe that the parties, we don't deny that there was a disagreement between the parents in this case. I think there's a lot more information that needs to be brought to light to the court as far as how the parties interact and that. I believe that the co-parenting is something that needs to be explored and maybe enhanced, but we deny that it was solely the mother's issue with what happened. And again, there are other documents and information that I believe the court needs in regards as far as medical records, any type of information from the doctor's office. The letter attached indicates that there was an altercation between the parties to evidence and that both parties were at fault for what happened. Why the doctor decided to not treat little David anymore, again, something that further needs to be explored by the court. So we would say that Ms. Mitchell was not in contempt of the orders regarding that. The parties had a disagreement. We know the parties have some trouble communicating, if I can put that mildly, for the court. Secondly, I think it's, we have two affidavits here that have nothing to do with the reason that we're here today. This is an incident that happened after why they were presented to the court for this hearing. First, regarding the affidavit of Grandfather Stone, my concern is that the court not received the entire information. Excuse me. The grandfather's affidavit indicates he wasn't there when the initial incident happened. In fact, it was the plaintiff mother that was called and was able to calm the child down. In fact, even according to his affidavit, which again, I feel these affidavits are inappropriate for today, but since it was brought up, the mother returned the child to the home where he was behaved and only became uncontrollable, according to this affidavit, after being home, after being at Dad's house. I don't know, I'm assuming Dad wasn't home at the time, it was only his girlfriend. And so to say that it was only due to Grandpa that calmed him down, that's kind of inaccurate, even based on the affidavit. And so what we find is that even now they're calling mother to calm down David. Now, does little David have some issues that I think need to be explored, some serious issues based on this incident? Absolutely. But, you know, at this time, I believe it's inappropriate to issue any orders until we have the full information before the court. And again, it was the mother that was called. It was the mother that took him, calmed him down. It was the mother that returned him to dad's house. And he didn't become upset or violent it was only after being home. And so, and anything that is indicated in this affidavit is all based on hearsay. So we find that it's inappropriate to issue any orders today. We'd ask the court not to and set it for an evidentiary hearing so that we may get some doctor's reports, some indications, some real eyewitness statements as to what happened, and get some direct evidence other than something that happened after.
Okay.
Judge, I'm also asking that Ms. Mitchell be lodged because, as I mentioned, this is the 9th time the court has issued a show cause, and there isn't anything that's curbing her behavior.
I understand. Well, we have a hearing. We'll address all of that at that time. Your request for immediate change of custody, I can't grant pursuant to statute and case law. I have to have a hearing to make a finding as it relates to the best interest factors, and we haven't had that hearing yet. So I can't grant that particular relief. Obviously, the plaintiff is opposing it, saying that things have not happened. That's why we have evidentiary hearings to decipher what's really occurred. So the court will not grant that at this particular time. The court will order that the parties would not speak with the child concerning these proceedings or about the other party. And you can prepare that order. Ms. McKenzie, I'll reserve on attorney fees pending the evidentiary hearing that we're going to have in this matter. And that will be the extent of the relief that the court will grant today. So when this
I'm sorry. Is there a chance that the court could move the evidentiary hearing up?
No, I don't have any time. I just don't.
Is the court also reserving on our request for lodging as a result of the incident in Dr. Byron's office?
I'm reserving on all the remedies at this point pending the evidentiary hearing. Court will note that this matter is before the court on the defendant's motion to set aside referee recommendation. Mr. Lyerlo, when I looked at your motion, I see there was a hearing on January 5th, 2023, at which time you stated there was an agreement as it relates to custody parenting time, and simply the referee incorporated that into the referee's findings. It now seems that what you're saying is that there's a basis to change that. And if that's the case, it doesn't mean that the referee made a mistake when they entered the order. And that's what we're here to, on at least to set aside the referee, is did the referee make a factual or legal error? If it's something that's happened since that hearing, the January 5th hearing, then you have to file a motion to modify, not to object to the referee.
Correct.
Okay.
And that's what we were discussing, because I when I called your office, she made that statement. I was like, I don't think he made a mistake. I didn't like the way that was stated because I don't think he made a mistake at all. It's just the current findings that of her going to her mother's every weekend, she seems more stressed out, and you know, stuff like that. I don't think Crudo made a mistake at all. I think he did a nice job on it.
Okay.
So
Then what you're going to have to do is file a motion to modify and set forth all of the basis for modifying. That way the plaintiff has an opportunity to respond, and she can say, I know you, whatever allegation you're going to say, that's not true, here's the case, whatever. But that provides her with due process notice of what she's going to have to respond to at that time.
Right.
Okay.
Okay.
Miss Lyerla, do you understand what's happening?
Yes, at this point, is there any way that we can get at least child support settled on this? That's what this comes down to.
That's not before the court today. Today simply is the issue of the referee's order, which the court is going to state that based upon what's been stated today and in the motion, that there's not a basis to set aside the referee recommendation. So the court will deny that particular request, and Mr. Lyerla has an opportunity to file a motion for modification if he thinks he has a basis to do so.
Okay, because what this comes down to is he just doesn't want to send her. He didn't send her for 88 days and now he has
I
to
have,
and he won't.
ma'am, I have no idea. All I'm saying, we're dealing with the referee's order and that's it today. If there's other matters, then you each have to file those specific requests in a motion and the court will address them on when it comes up before the court on each of those and set forth your factual basis, legal basis, et cetera, in the motions, and then the court will address those at that time. I can't address things that aren't before me.
Okay, so do we follow this current order until then?
That order remains in effect until it's modified.
So what do I need to file in order to get child support taken care of?
Well, you can contact the front of the court and contact your enforcement officer, and they can proceed with enforcement action if that's necessary, or you can file a motion seeking enforcement. It's up to you.
Okay, because they told me to ask you, so
Well,
they don't.
but the enforcement officer, if you inform them that you haven't received support, they can take enforcement action to enforce the order.
Well, I'm receiving it, but I'm receiving it based on the original order back in August, not the current order. And
Well, it's probably because the other order's at least been stayed or at least been held up as a result of the objection. Now that we're again vacating that and denying the request, then they should modify their order accordingly.
okay,
Okay?
Mr. Podol,
Thank
can you
you.
let her know?
Thank you both. The court will answer.
There she is. Okay, can everybody hear me now?
Yes.
Good afternoon to all of you. Mr. Toth, been informed that you do have resolution in this matter. Is that correct?
Yes, Your Honor. We had a mediation session with Mr. Brundage where all of the issues in the case were resolved. The terms of the settlement were placed on a record, which was a recording. I think both Mr. Podol and myself made the recording, and my office is in the process of drafting a judgment. The judgment's delayed, quite frankly, because our server was down Wednesday through actually yesterday due to the ice storm. So we're a bit delayed. So, Your Honor, unless there's an objection from the other side, I'd like to go ahead and be able to at least preserve the proofs with Mr. Baiocchi this afternoon.
Okay. Mr. Podol, I don't assume you have any objection to that.
I do not, Your Honor.
Okay. Mr. Baiocchi, I'm going to have you raise your right hand. We'll have you sworn in, then we'll take some brief testimony from you.
Okay.
Okay, and if I didn't know before, plaintiff is attending via telephone. All right, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Mr. Toth.
Mr. Baiocchi, you were married to your spouse, Elena, on September 23. Correct. And you had been a resident of Calhoun County for a period of 6 months prior to the date that our office filed the complaint for divorce. Is that correct?
That's correct.
And during the marriage, there were 2 children born, both whom are minors. It would be Leo and Venice. Is that correct?
Correct.
To the best of your knowledge, is your spouse presently pregnant?
No.
You had alleged in your complaint for divorce that the marriage relationship had broken down to the extent that the objects of the marriage had been destroyed, and there was no reasonable likelihood that your marriage can be preserved. Was that statement true on the date that you filed the complaint for divorce?
Yes.
Does that remain true today?
Yes.
Mr. Baiocchi, as stated on the record, we participated in facilitative mediation in my office. Do you recall the process?
Yes.
And at that point in time, there were statements placed on the record by or placed and recorded by our mediator, John Brundage. Do you recall the statements that he made?
Yes.
And you understand that the intent is for our office to prepare a judgment of divorce that is reflective of all of the statements that were placed on the record as they relate to your children, parenting time, custody and going up through property, including real estate, retirement accounts, and personal property and debts, correct?
Correct.
And you understand that once the judgment is reduced to writing and approved by Judge Kirkham, that you, as well as Elena, will be bound by those terms.
Understood. Correct.
Thank you. May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing that there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter. You're not divorced until we actually sign that judgment and the UCSO, et cetera, in this matter, but that'll take some time as it's being prepared. And at that point, you don't have to do anything further, but once it's signed, then you'll be divorced at that time. Thank you all for coming to a resolution in this matter, and we will excuse you. Have a good afternoon and hope everything works out. I guess that will be my first question is how have we allowed this to get 301 days old?
I believe it is a result of my client's first attorney, and that whole nightmare of a situation is how we got to this point. All parties have now been for the genetic testing. We are just waiting on the results.
Okay. Do you have a set time or when you think that's going to be in? They're usually pretty quick on that.
We think it's a week or two, which would put it this Friday or next Friday.
Okay. Why don't I do this? I'll set this for a status conference about 3 weeks or so out. It'll be on a Monday at 1:15, and then we can at that point check back and see where we're at. And again, depending on what happens, can set a trial date if we need.
Okay.
Your Honor, if I may, we were before you, I think, February 7th.
Okay.
February 7th, and I entered the order for support under the 7-day rule and submitted the calculations and whatnot to the front of the court. I'm wondering what the status is, if we have to do something more for a payment withholding order.
No, if that order went through, that's all you need to do, and they will institute a withholding order and stuff.
Excellent. Okay, thank you, Your Honor. I just didn't want to be derelict.
Nope.
Okay.
That's fine. Thanks for asking. What we'll do is we'll let you go then and see you back in about 3 weeks, and hopefully we have the results of the well, good afternoon to all of you. I guess I'll turn to you, Mr. Umloff. You've been in the case longer. Court will note that there was a court structured plan which went into effect on February 23rd, 2022. And then subsequent to that, there was an annual report of the Guardian filed on June 9, 2022. Actually, when I was looking at the court file in this matter, I didn't see anything other than that this was on the schedule. So enlighten me, what are we doing today, Mr. Umlauf?
This is the annual review now that after the court structured plan was entered. Since our last hearing, I've spoken with my client earlier today. He has participated in a psychological evaluation, which was required with Dr. Haugen. He's followed the recommendations in that evaluation. He is in the process of engaging with community fatherhood. He's been emailing back and forth with the gentleman in charge of community fatherhood to get something set up there, but has not completed it. He has participated in parenting classes that were recommended by Dr. Haugen in his psychological evaluation. He has not done specifically the Healthy Relationships program itself, but has done similar, specifically 1-2-3 Magic and the Love and Logic program recommended by Dr. Haugen, which he was better able to fit in with his work schedule. The one thing I am not sure of from talking with my client is one of the provisions of the court structured plan was that Romel was going to continue engaging in counseling with both father and grandmother involved at the direction of the counselor. I'm not aware of any counseling that's been done by the minor child. Perhaps Leandris could enlighten us as to what's been going on there.
Okay, well, it does say by the direction of the counselor, so I don't know if there's another counselor involved or not. It was pretty sparse in the file. So I'll ask Mr. Whitehead, he represents Miss King. Do you know, Mr. Whitehead, has there been any counseling for the child?
I don't believe so. And Leandra's shaking her head. So we have not seen that there's been any counseling.
Well, it sounds like obviously where we're at is there's a few other things that need to be done under the court structured plan. I guess I'd say, Mr. Umlauf, you're going to have to, if you would, you'll have to file all those, like if he's completed various programs or whatever, you'll have to, maybe provide us with some certificates or whatever there might be showing compliance. And likewise, if it doesn't appear that the child's in counseling, it does state that the child will engage in counseling with both the father and the grandmother under that order of February 23rd. So again, obviously the intent of the court would be to enforce its orders. And so I guess I'll leave that up to you, Mr. Whitehead, to talk to your client about getting that accomplished. And then Mr. Umlauf can work out with his client to complete what is previously ordered. And I would say ordered, but it was by stipulation. So the parties agreed to it as well. And so I think that needs to be completed. And then maybe we need a evidentiary hearing or someplace. I don't know at this point. I would say, Mr. Umlauf, when Mr. Whitehead came in before you got on, he did state that it was his intent at that point, because we didn't have an appearance from Mr. Whitehead, and we're saying, okay, are you here on this case? Yes, I am. He's stating and say it's his intent on behalf of the guardian to file an action for custody. So that's the extent of what was said. Is that accurate, Mr. Whitehead, as to what you said you were going to do?
Yes, Your Honor. And we can follow up. You should, if the court hasn't received my appearance on this case, then it should be in the mail arriving any day now. We haven't as of last night when I reviewed the file. Okay. So I think we just got hired just last week or so. So I'm sure it's probably in the mail.
Okay. Well, I just thought that because that was mentioned on the record that Mr. Umlauf needed to know what was going on, what had been stated. So
sure. Oh yeah, I appreciate that.
Respond accordingly as well.
I had a couple questions. Was in the current order, does it say anything about an abuse, domestic abuse class?
I
didn't, and if
I'll tell you what it says is under that, it says that the father will agree and to engage in, have a psychological evaluation, follow all recommendations of the evaluation, shall enroll and engage in the healthy relationships program, it says, or similar program, which apparently, as Mr. Umlauf states, he's done, shall participate in parenting classes, engage in community fatherhood, maintain stable employment, and obtain and maintain stable housing. And that's the extent for the father.
And Mr. Umlauf, you didn't address the housing situation. As we understand, he's still with his grandmother, that he doesn't have his own stable housing. Can you enlighten us on that?
Yeah, Street. I brought you the lease paper to your at the desk, so thought you would have got that.
And could you clarify, is that with your mother or are you living alone?
Here, but she's currently looking for an apartment right now, so she's gonna be moving out pretty soon.
Okay.
Well, it sounds like obviously because there's going to be some additional proceedings, it sounds like maybe what best is the court would simply, that consent order continues, so the court will continue the court structured plan, and it's probably at this point the attorneys should exchange whatever they have or whatever they believe that they need, and then I guess Mr. Whitehead will proceed with his either his motion or whatever however he's going to bring it before the court, but probably by motion, And then we would have to have a subsequent hearing in this matter.
Yes, Your Honor. If Mr. Umlauf, if you could, yes, please share, I guess, what those certificates of completion and so on, and then I'll share those with my client and the psych eval so we can see what the recommendations were, so on.
Yeah, I'll pass along what I have.
Okay, thank you.
Do you have the evaluation, Mr. Umlauf?
I do. I'm
Okay.
actually holding a copy of it in front of me.
Okay, yeah, provide that to Mr. Whitehead so that he has that, he can review it. And then I guess if in this particular matter, if he's filing his motion, we'll have a hearing on that. And at that point, maybe we have to proceed with some sort of a scheduling order. So if additional discovery is necessary, that we can provide for that and anything else that might be necessary in the case.
Yes, Your Honor. Now normally, and I don't know this particular court, they have these guardianships in the probate side, and then there's if we filed a third-party custody, either a complaint if there's not a current custody case or a motion within an existing custody case, we would file that in the family court, and then they're not necessarily the same judges. And under Michigan law, then once a custody case is filed, then it supersedes a guardianship action until the custody case is played out. Do you have? Would you be the same judge on that?
I would, because I handle all cases involving children. The other judge only handles basically domestic at this point, just started January, but she is handling stuff, but it's not when there's children involved. So it would be assigned back to me.
Excellent. Thank you.
Okay. Mr. Umlauf, is there anything else that you need or we need to address today before we conclude?
Not on my end, Your Honor. Thank you.
Okay. Mr. Whitehead, anything else?
Just also, Mr. Umlauf, if you could also send a copy of the lease agreement as well, I appreciate it. And then those certificates of completion. Thank you. That's all I have, Your Honor.
Okay, thank you both. And it looks like we're moving ahead at least. And but I'll tell the parties just so they know that that order, the consent order from last February, still remains in effect. So you still have to comply with that at this point. And that means all the provisions of the order. I know it has parenting time, et cetera. So make sure that you're complying with that order. And appears that that's all we need to do today.
The respondent is Skylar Mitchell. Mr. Mitchell was arrested on an FOC warrant. He posted a $500 bond. He's had income withholding in place for the last 3 months. So further, the court's asking that we forfeit the $500 bond that he posted and dismiss this matter.
Court will forfeit the bond previously posted by Mr. Mitchell and will dismiss the action.
Giuseppe Cuba Besso.
Okay, you're gonna have to give me that name again.
His first name is Giuseppe. The 3 respondents failed to appear for referee hearings. Further, the court's asking that bench warrants issue for their arrest and the bonds be set per statute.
Court would enter bench warrants for Mr. Cuba Besso, Mr. Terry, and Mr. Clemens as a result of a failure to appear at their respective referee hearings. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater. And further, the court would assess court costs of $150. Ms. Hester, is everybody else just comes on and yours just kind of fades in and out. You must have some special feature on your camera.
I don't think it's special. I think it may be special. So I have quite a few for this morning.
Mr. Halstead, as a result of his failure to appear on today's date, the court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater. Mr. Hollis, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Court will find that Mr. Hollis does freely and voluntarily waive his right to an attorney. Mr. Hollis, we're going to take some testimony from you, Ms. Petrulio, so we'll have you both raise your right hands, be sworn in, then we'll proceed.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Yes.
25 DP. Mr. Hollis is before the court for a compliance hearing. He last appeared in court on December 28th and an agreement was reached. He was required to pay a total of $348.50 commencing January. Nothing has been paid. He did indicate in a pre-screen this morning that he paid $100. I don't know how he paid it online, I'm guessing, late last night. His current support obligation is $295. The arrearages were set at $50 a month on December 28th, but with an arrearage that exceeds $12,000, I think that's unjust and inappropriate, and would ask that the arrearage be set pursuant to the Michigan Child Support Guidelines, which would be right around $150 a month as it stands now. The last payment that was paid was $200 to resolve the bench warrant back in November. He also made a payment to get his driver's license back and promised that as soon as he had his license back, because he's an Uber driver in Nevada, that he would commence payments, and nothing has been paid since he's received his driver's license back in December. He should have paid the 2 months at $348.50 for a total of $697. Nothing has been received. And that is about all I have right now.
Okay. Mr. Hollis, do you dispute or contest any of the statements made by Ms. Petrulio?
Yes. When I called last time I spoke with someone, they told me I was supposed to pay $50 a month for 2 months, and then it'll get reset when we had this hearing today. I missed January's payment because I wasn't able to get my license till near the end of January because I had to wait for the clearance letter to come. Then when the clearance letter came, I still had stuff I had to do with the Secretary of State, Michigan, and the DMV here. So I wasn't able to pay in January, but last night I paid the payment of $100, and I thought that I was under the impression that I was just supposed to pay the $50 a month for 2 months until I got back stable, and then starting this month, I would start paying again like my regular amount.
Well, the $50 per month is on the arrearage. That's not the other $295 amount. That's the current support obligation. The $50 is only on paying the arrearage.
Yes, I understand that, but I thought I was getting like a 2 month time to get my basically to get stabilized again, because that's how it came across when I talked to the lady last time. And like when I look at the order online, it said pay $50 a month. I wasn't aware that I had to pay the $348.
Yep. Okay. But yeah, you understand that now, sir, right?
Yes. Yes.
Okay. Do you have any questions for Ms. Petrulio?
No.
Okay. What would you like to tell me, sir?
That I'm getting everything back under control now. I paid the $100 yesterday because I thought that's what I was obligated to pay. She said she wants me to pay $150 in arrears, so that would make my monthly payment probably what, $448? Yeah, $448. And I have no problem with that.
Okay, so you can pay the $150 on the arrearage?
Yeah, and it'll be $448 total, correct?
What's the amount, the total, Miss?
Yeah, it'd be about $448.50 a month.
Okay.
So basically $450.
Okay. And you are working now. You understand you're going to have to pay that each and every month, sir.
Yes.
Okay. And you believe that you can pay that?
400 would be easier, but if that's what I have to do, that's what I have to do. I'll just have to work more hours.
Okay. Can you work more hours, sir?
Yeah, I can.
Okay. Well, why don't we
but if it could be 400, I would really appreciate that, because that's 100 a week. And that's probably how I would pay it.
Well, what I'm going to do then is I'm going to modify the amount of payment on the arrearage. I'm going to increase that to $100, not to the $150, which would be the guideline amount. So that would again bring your amount just under the $400. You understand that?
Yes.
Okay.
And can I pay it weekly, or do I have to pay it all at once?
You can pay it anytime you'd want, just so that you pay that each and every month. Okay, what I'm going to do is I'm going to adjourn this matter 90 days to monitor your compliance. So I'm giving you 90 days to see that you're going to comply with the new order, which would go into effect here shortly when Ms. Petrulio gets that prepared. You understand?
Yes, and I appreciate that.
So I'm giving you 90 days to see what you're going to do. If you don't pay during that 90 days, then I'll tell you at that time when we have the next hearing, be prepared to go to jail, because, you've said you can pay this. I've in fact reduced the amount to less than what the guideline amount would say, so that you can in fact comply. And so we'll see what you do in the 90 days, but you'll get notice. You'll have to be back at that hearing, and then we'll see what you're doing. Okay.
Okay. And just one more question. After the 90 days, like when I pay, or like even 6 months, 9 months when I pay, is there any way, or like how can I get like visitation with my sons?
You'll have to file a motion. You just file. That's independent of any support obligation. So you file a motion with the court and state the basis and what's happened and what's not occurred. And the court, if there's an order in place for visitation, the court will enforce that. If not, then you'd have to put in place a visitation order, and then we'll proceed in that way.
Okay, so is the motion like, is it on like the court's website, or?
Well, you can go down to the clerk. I don't know if it's on the website or not. You can go to the clerk's office, and the clerk has what they call a pro per motion packet that they would give to you, and it's pro per because you are representing yourself. That's all it means, is that you're appearing in pro persona. And you can just tell them you want to file a motion to get your parenting time, and they'll give you the forms.
Okay, it's called a pro per motion.
Yeah.
And then I filed that for parenting.
You file that, you have a notice of hearing, and you would schedule that for a Monday morning at basically 10:30 a.m. And you have to provide the other side 9 days notice by mail, and then we would be able to have the hearing.
Okay, thank you.
Okay, that will conclude this matter at
In the matter of
10:27 a.m.
Calhoun County Foster Care versus Mary Lynn Stananzik, docket 2021-1413 DZ.
Could you give me the how to pronounce the last name again?
Stananzik.
Bonanzik?
S-T-A.
Okay. Staman. Okay. Stananzik.
Yes. She was ordered to appear this morning for a bench warrant hearing. She did phone in front of the court, spoke with her. She did waive her right to appear before the judge. Front of the court is requesting that the bond that she posted in the amount of $100 be forfeited, that Ms. Stananzik be ordered to enroll and participate in the LEAP program, make a $40 lump sum payment by March 3rd, 2023, and adjourn this matter until April 19th, 2023 to monitor her compliance.
Okay. Court would order that Ms. Stananzik would, in fact, the bond previously posted would be forfeited, that she would participate in the LEAP program and make a lump sum payment of $40 no later than March 3rd, 2023. And we'll adjourn the matter to April 19, 2023 at 8:00 a.m. to monitor her compliance. Good morning.
Morning. All right, let's go ahead.
Okay, sir, in this matter, you're before the court charged with civil contempt of court as a result of your failure to pay child support and or related expenses Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yes, sir.
Court, in this matter, has appointed Mr. Sullivan to represent you in this case. Have you had sufficient opportunity to speak to Mr. Sullivan?
Yes, sir.
And Mr. Sullivan, are you ready to proceed?
Yes, Your Honor.
Okay. What I'm going to have is Ms. Mouton and sir, I'm going to have you both raise your right hands. I'll have you sworn in, then we'll proceed.
Raise your right hand, please, Mr. Shorter. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Yes.
Okay. Go ahead, Ms. Mouton.
Your Honor, Chad Shorter is before the court for a bench warrant hearing. He's currently ordered to pay $84 a month for current support, $42 towards his arrears, $3.50 for service and processing fees, for a total monthly obligation of $129.50. Last payment received on this docket was on September 10th, 2021, in the amount of $3.40, and that was through an income withholding. We are here because Mr. Shorter failed to appear for a show cause hearing before referee Couteau on December 9th, 2022. This is his second show cause, second bench warrant, and he's had one previous finding of contempt. I did measure compliance over the last 12 months. Mr. Shorter should have paid $1,554. He's paid nothing, so that is a shortfall. Total arrears on this docket are $3,624.20 through February 28, 2023. Mr. Shorter did book into Calhoun County Jail on February 17, 2023, so that would give him credit for 12 days. And he did have a prior 20-day jail sentence on October 10, 2018. And for the record, Mr. Shorter did report that he had employment from January 2022 through December of 2022. His employer would not send in payments, but Mr. Shorter failed to make payments on his own also.
Okay. Mr. Sullivan, do you dispute or contest any of the statements made by Ms. Mouton?
No, Your Honor.
Do you have any questions for Ms. Mouton?
I don't.
Okay. Any proofs, Mr. Sullivan?
I'd like to make an offer of proof, if
Okay.
that's permissible.
Go ahead.
So I had a good talk with Mr. Shorter, and I think the most significant takeaway from our meeting was that he has a strong relationship with his son. He's 8 years old. However, the relationship is impacted to some degree on a lack of transportation for Mr. Shorter. He's certainly in a financially strapped way. Although he did have a job for a period of time with Brady's Pub, they were not willing to do income withholding, and as a result, he lost his job. While he did work there, he did not have significant income from that employment, so barely managed to stay afloat. Again, not even able to afford a car. As I said, he has a strong relationship with his son, even to the point where the mother of the child, Casey, would come and pick up Mr. Shorter to have parenting time with his son. So to me, that's the most significant takeaway from his circumstances. He did have surgery on December 1st regarding his broken jaw, and which resulted in teeth-related issues and multiple appointments with the dentist. His last appointment is scheduled for March 24th. That would relate to the installation of dentures from the broken jaw and the resulting other damage. He does have a hold from Berry County. His hope, Your Honor, is to finish up with his situation here and then go to Berry County and hopefully be out in time to make that March 24th appointment. So he does have a $2,000 bond in Berry County, so he will continue to be incarcerated even if this court were to give him a time-served sentence. So that's what we would be asking for.
Okay. Mr. Schroeder, in this matter, you had worked for approximately the year of the 2022.
Yes, sir.
How much were you making at Brady's Pub?
I was a bartender, so it varied from night to night. I only worked 3 days a week.
Okay. Well, it might be vary because obviously that's your tips, et cetera. But what was your hourly?
My hourly was $7 an hour.
Okay.
It was anywhere from 5 hours to 7 hours. And then everything else was just tips.
Okay. What would you figure you'd make in a normal week?
In a week, about 300, maybe 4 if it was good.
Okay.
Maybe.
Okay. And during that time, that year that you worked, you didn't pay anything on the child support. Why was that?
I begged my employer to fill out the forms and she would not. And I just put it off in my head when I shouldn't have. And I was spending time with my son. It's not like I wasn't doing that, but
okay,
totally slipped my mind. I'm so used to having it just taken out of my paychecks. I have a 21-year-old that just got off of child support. So
okay.
And
So you're saying that during that entire year that you were working and making that money, each and every week, it slipped your mind about paying child support.
well, I couldn't even have a car. I didn't have a car. I was walking to work every day.
Okay.
I would get rides home most of the time, but I was walking. And I lived at 10 Mile Road. That was 7.2 miles, I think it is. It took me about 3.5 hours to get to work every day.
Mr. Sullivan, is there anything else you have for your client?
No, I think that's sufficient. You know, the circumstances here are not the best, but again, a strong relationship with the son, and that's a good foundation from which he can move forward.
Okay, and that's good. That's correct. What the court's going to do in this matter, the court's heard the testimony of Mr. Shorter in this particular matter that during the period of January through December 2022, he did work at Brady's Pub. He worked, as he stated, he made approximately $300 to $400 per week. That he didn't pay support during any of that particular time and paid nothing, as he claims it just slipped his mind in this particular matter. And as a result, he's incurred an arrearage in excess of $3,600. His obligation is not substantial. It's $129.50 per month. He could have easily paid that. He had the income sufficient to pay that, but failed or refused to do so. The court will find as a result that he did have the present ability. He failed or refused to pay, and therefore he is in contempt of court. Anything as it relates to sentence, Mr. Sullivan, other than you've mentioned?
Nothing beyond what I've mentioned.
Okay. Court is mindful of that court would note that Mr. Shorter has had a prior jail sentence of 20 days back in 2018 in this particular matter. Notwithstanding that, he again has continued to be non-compliant in this case, and again, especially when he had the present ability. I get people all the time that don't have the ability to work or have other issues, but not the end of basically had a year of making income without any payments in this particular matter. So what the court will do in this matter is the court is going to sentence you, Mr. Schroeder, to 45 days in jail with credit for 12 days served. The court would set a purge amount in this matter in the amount of $500. If you're able to pay that, then you would not have to serve the remaining time. Any questions, Mr. Schroeder?
No.
Okay, thank you. That will be the order of the court. The court will adjourn this matter at 10:43 a.m. You're free to go. Thank you. Okay. Ms. Sanchez, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges? The court has appointed Mr. Sullivan to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sullivan in preparation for this proceeding?
Yes, sir.
Okay. And Mr. Sullivan, are you ready to proceed? Okay.
Yes, Your Honor.
Ms. Sanchez, I'm going to have you raise your right hand and be sworn in. Ms. Mouton has previously been sworn.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Ms. Mouton, you can proceed.
Your Honor, the respondent Kelly Sanchez is before the court in 3 different matters. She's here for a bench warrant hearing because she failed to appear for a show cause hearing on December 16, 2021 before referee Couture. On this matter, she's currently ordered to pay $62 per month for current support, $31 per month on arrears, $3.50 for service and processing fees, for a total monthly obligation of $96.50. Last payment received on this docket was on August 4th, 2021 in the amount of $44, and that was through unemployment. This is her 3rd show cause, 7th bench warrant, and she's had 1 previous finding of contempt. I measure compliance over the last 12 months. Ms. Sanchez should have paid $1,158. She's paid nothing, so that is her shortfall. Total arrears on this docket are $1,800.37 through February 28th of 2023. In the matter of Parks versus Sanchez, Ms. Sanchez is ordered to pay $88 per month for current support, $44 on arrears, $3.50 for service and processing fees, for a total monthly obligation of $135.50. Last payment received on this docket was on August 4th, 2021, in the amount of $62.43 through unemployment. This is again her 3rd show cause, 7th bench warrant, and she's had 1 previous finding of contempt. I measure compliance over the last 12 months. Ms. Sanchez should have paid $1,626. She's paid nothing, so that is her shortfall. Total arrears on this docket are $2,209.30 through February 28th. In the matter of Sanchez versus Sykes, Ms. Sanchez is ordered to pay $326 for current monthly obligation, $163 on her arrears, $3.50 for service and processing fees, for a total monthly obligation of $492.50. Last payment received on this docket was on August 4th, 2021, and the amount of $231.27 through unemployment. This is her 2nd show cause, 4th bench warrant, and she's had 1 previous finding of contempt. I measure compliance over the last 12 months. Ms. Sanchez should have paid $5,910. She's paid nothing, so that is her shortfall. Total arrears on this docket are $8,910.81 through February 28, 2023. Ms. Sanchez did book into Calhoun County Jail on February 16, 2023, so that would give her credit for 13 days. And she has had a prior 30-day jail sentence on October 30th, 2019.
Mr. Sullivan, do you contest or dispute any statements made by Ms. Mouton?
No, Your Honor.
Do you have any questions for Ms. Mouton?
I don't.
Okay. Any proof, Mr. Sullivan?
Offer of proof with the court's permission.
Okay, go ahead.
We got a call?
Sorry, 1 minute, Judge. My battery alert went on and I don't want to lose you.
Okay.
Your Honor, while I do this, Ms. Sanchez has pending before another court 2 felony cases. And bonds are set and not posted in those cases. So that compounds her situation, and her a reason for being incarcerated. So I talked to Ms. Mouton earlier today about the idea of adjourning these. Perhaps we didn't talk about the bond issue, but I assumed that that meant to modify the bond to allow her to address the felony charges. And then at some point, she hopefully will be released and get on an employment track that will allow her to comply with the court orders.
Okay. Well, Ms. Sanchez, in this matter, you've basically not paid anything since August of 2021. Let's say in the last year, 2022, were you working?
I did work for Best Western Hotels for a little bit.
Okay. You say a little bit. How much?
A couple of months.
Okay. And during that time, how much were you making on a weekly basis of income?
I'm not quite sure exactly. I was making $10 an hour, only working like 30 hours a week. So roughly probably about 300.
Okay. And so you're doing that for a couple months. When you weren't working, what attempts were you making to acquire employment?
Applying the jobs and saying I got an interview.
Okay. Let's say, how many applications would you say you put in on average, a given month?
A given month? I'm not quite sure. Whenever I would get a job offer through like Indeed or Snag a Job, like I would apply hoping I got a phone call or an interview or something. And that was probably roughly 20 to 30 a week.
Okay. Why do you think that you were not, you didn't get any jobs? Why were you not employable?
A lot of them required like transportation. That's like your own transportation, and I don't have a vehicle at the moment. I'm guessing, because the background checks, maybe possibly with having the warrants, I didn't pass the background checks, but I'm not sure.
Okay. What's your educational background?
A high school graduate with some college. I have been looking at some colleges about going back and finishing my degree.
Okay. Obviously, there's a substantial labor shortage at the current time, and if you go down the street, almost every business is looking for employees. Have you went into jobs like that just by seeing their signs and all of that and sought employment?
Well, I was supposed to have a couple of interviews before I got arrested. One for Little Caesars, and then I can't remember if it was Snack Works or if it was the what is it? It's like True Angels or something, like home care. I was to have an interview with, but I'm not quite sure how that's going now that I've been in jail.
Okay. Have you applied to work at any places out in the Fort Custer Industrial Park? There's a lot of those employers out there that are just looking for people.
Yes.
Okay, who did you apply to out there?
I applied through like on staff, employment group. What was the other one? It wasn't Kelly Services, but it was, I want to say employment group, maybe.
Okay. Why didn't you go directly to the employers? Because they're having direct hires. So you can just simply go out to the plants and walk right in and ask about employment.
I was not aware of those at the time.
Okay. Tell me, what other efforts have you made to acquire employment, let's say in the last year?
I mean, what other efforts can I do other than applying for jobs and hoping to receive a phone call or?
Yeah, those are things you could do. You could follow up on, you could follow up when you put in an application. There's, like I said, you could go in direct. You could, if there's anything else, I'm willing to hear anything else effort that you've taken. I mean, it's very easy to sit home and just simply on your computer and try to apply and take another action. It doesn't take you but a few minutes, but I'm looking to see what effort you made.
I mean, I've called, to see about, whether or not they've had a chance to review my application or not. It is a little more difficult to go into places personally, with the lack of transportation. But I'm hopefully getting that resolved, if I can get out sometime soon.
Okay. You've got some outstanding felony charges. Have those been resolved and simply you're waiting to have those concluded, or what's happening in that regard?
I have court for them on Friday to hopefully have them resolved. If not, they should be resolved by next Wednesday, I'm hoping.
Is there anything else that you'd like me to be aware of, ma'am?
Just no, please. I am trying. I really am. It's been a little difficult. I don't normally have this much of a struggle getting a job. I mean, I worked for Subway for 9.5 years. But I am trying.
Someone else on the line.
Yes, it was Mr. Sipes.
Sipes, okay. Mr. Flores, is he trying to get back in, or
He's dropped out of the call 2 times, and I cannot send him messages.
Yeah, okay. Well, if he comes back in, then we'll have an opportunity to hear from him. Anything else, Mr. Sullivan?
No, I would just say that there is a balance of factors here, some that are positive and some that are negative, and in balance, I think if the court ultimately does find the defendant in contempt, that the court would give her a time served sentence to let her navigate her way through those felony cases and get out and get a job.
Okay, thank you. Well, in this particular matter, the court has heard the testimony from Ms. Sanchez that, again, she has these 3 cases that she has not made any payments in this matter since August 4, 2021. So it's basically, it's been over 1.5 years that she hasn't made any payments. In the last year, she said she was employed. For a couple months, she was making approximately $300 a week at that employment. However, during that time when she was making that money, she didn't pay any of it towards any of the support obligations in this particular matter. She has her main issues concern not having a vehicle. And again, she had apparently some outstanding warrants, and that may have shown up in the background check, as she states, but she does have a high school education. She has some college, so she is educated sufficient that she could acquire employment. The court would note that she said she made put in a number of applications, so that's a positive aspect on her part. And that she said even that she's followed up on it, but she's not been able to acquire the employment. So the court's not aware of why she hasn't been able to acquire employment. It seems like based upon the labor market and again, the demand for labor, that she should be able to acquire employment. She's not been able to do so, but the court simply will focus on, again, the time when she was employed in the last year and did not pay anything on the support obligation. So the court will find that she did have the present ability and failed or refused to comply in this matter, and the court will hold her to be in contempt of court. Anything before sentencing additional, Mr. Sullivan?
Nothing additional. Your
Okay.
Honor.
Well, court will note that she does have a prior 30-day jail sentence that she served back in August, or was sentenced on August of 2019. And the court takes that into consideration. The court notes she has her other felony charge in this particular matter that she's going to have to negotiate. But notwithstanding that, the court could sentence you, Ms. Sanchez, up to 90 days. I'm not going to do that. What I am going to do, however, I'm going to sentence you to 45 days in jail with credit for 13 days served. The court would set a purge amount in each of your cases in the amount of $250, so a total of $750 to get out of serving that particular time in jail. That will be the sentence. Anything else, Mr. Sullivan?
Sorry. No, thank you, Your Honor.
Okay. Ms. Mouton, anything else?
No, thank you, Your Honor.
Okay. The court will conclude this matter at 11 o'clock a.m.